FishFAQ.
The primary function of a trademark is to identify the source of goods or services and prevent consumers from confusing them with those from other sources. To that end, for a trademark to be eligible for registration, it must have a distinctive character. Trademark law recognizes different levels of distinctiveness. From least to most distinctive, trademarks and service marks are commonly referred to as being generic, descriptive, suggestive, arbitrary, or fanciful. The least distinctive are generic marks. These are terms commonly used by the public to refer to goods or services. For example, a generic name for steakhouse is steakhouse. It would be improper to allow someone to register the term steakhouse when referring to steakhouses. Generic marks are never registered for the goods or services that they describe. Descriptive marks merely describe goods or services to which they relate and straddle the world between registrable and non-registrable marks. To the extent that descriptive marks are a little better than generic, they're unregistrable. World's Best Steakhouse would be an example of an unregistrable descriptive trademark because World's Best merely describes what type of steakhouse it is. Descriptive marks can be registered if they achieve secondary meaning, in which the relevant public comes to associate the mark with a particular supplier of the goods or services. For example, the color brown is in the public domain. However, a medium shade of brown is now associated with delivery trucks because the general public has come to associate that color with UPS. Suggestive marks use suggestive terms to imply what the good or service is. Sizzler is a marvelous suggestive mark. It doesn't directly describe a steakhouse, but rather implies steakhouse because sizzling makes people think about steak. Arbitrary marks are actual words that have no association with the underlying goods or services. Claim jumper is an example of an arbitrary trademark for a steakhouse because the name doesn't relate to steak at all. The most distinctive category would be fanciful trademarks. These are invented words, and they only have meaning in relation to their goods or services. Exxon for petroleum or Pepsi for soft drinks are two examples. If you have any questions, contact us at fishiplaw.com.
FishFAQ.